been the immigration specialist and assistant public defender for the Dallas County Public Defender's Office for the past 2 years. Before that, she was a criminal justice work fellow and staff attorney at Public Counsel in LA, where she directed a monthly legal orientation program at the Music Immigration Defense Center and ran the legal fellowship at the Santa Ana. She's a graduate of Youthful law and also welcome, Jordan. So I just wanted to say thank you so much, Brandon and Dahlia and Himika and Yasmin for having me here today. It's really exciting to talk to you guys about immigration law and crime, specifically with juvenile. I think this is an area of law that's somewhat neglected, definitely on the defense side. I think it makes immigration a little bit squeamish. So I think it's really great that we're going to have some time to talk about this today. As Dahlia mentioned, I work for the Dallas County Public Defender's Office, and I work doing immigration advisals for criminal defense attorneys all day, every day. It's the first program of its kind in Texas, which is among the nation, because there should be people doing this all over the state. The first public defender to have a full-time immigration attorney. Hopefully that's the thing that's changing. I think Travis County is going to get someone soon, and hopefully it's the thing that we're going to start to see throughout the state. It came out a while ago. This isn't exactly new law. So it's exciting, though, that we got a grant from Texas Immigrant Defense, a 4-year grant. Hopefully, at the end of it, I'm supposed to do a manual that will be on all the immigration consequences of all the Texas criminal offenses possible. It's moving a little bit slowly, but I got 2 years to finish it, so that'll be a resource that I'll share with you guys by next weekend. Yeah. So one thing talking about juveniles specifically is that while the consequences aren't as pronounced as they are for adults, they definitely exist. And so that's a little bit what we're going to talk about today. I might not be far. One thing that I'm going to say at the beginning is a little bit of a word for immigration attorneys from a person who now works on the defense side. I used to be, obviously, an immigration attorney solely, and I was called defense attorney with really outrageous requests to advance because that's what I needed for my client. And now that I was on the defense side, I'm a little bit more sensitive to this. The defense job was pretty hard. I mean, having somewhat better conversations with immigration attorneys and defense counsel. One thing is, just because a conviction is really bad for immigration doesn't mean that it will just disappear. Someone says, oh no, my client can't plead with that, it has to be. Well, it doesn't exactly work like that, unfortunately, you know. So sometimes you have to try to help things, and a lot of times the district are really tough, right? It's really hard to work with that. So I think it's important to understand that you may want to offer options to a defense attorney that you think would be better, but straight dismissal on charges is not very realistic, even if it's really bad for immigration. And that sense too, going to trial can be really risky, even if the conviction is bad, especially if the person is looking at, let's say the 17-year-old is looking at real felony time. That's a real consideration to take. Although the conviction could be bad, you have to recognize that your client could be looking at prison. Maybe leave and stuff on immigration, and that has to happen. So just trying to make that conversation go a little bit more smoothly. Also with non-detained criminal cases, just like non-detained immigration cases, really slowly. I was working with a nonprofit recently, and they're calling me every week to get involved in a criminal case. It doesn't move that fast, so the person's not in jail. So just another thing, like non-detained immigration cases, they're going to move slowly. But it's great to keep checking in just to understand how long it's going to take. Another thing is just the terminology issue. A deferred adjudication, criminal attorneys don't think it's a conviction because it's not in the criminal context. And you will drive criminal attorneys crazy talking about like a conviction. They'll interrupt you. They'll say it's not a conviction, it's a deferred adjudication. We get that it's conviction for immigration purposes. It doesn't need to keep saying that. But for immigration purposes, because this is a conviction, otherwise you end up just like shouting in each other's faces. This is like my first class in my job. Okay. So I'm sure this is familiar for most of you. You guys know that Michael J. Fox was an immigrant visa violator when he first came into the U.S. I found that out on the internet. And like the entire SIJS team of Warner Bros. Great immigrant team. So one thing I think, like as most of you guys probably noticed, but it's concept to understand when you're looking at immigration a long time, is inadmissibility and deportability. And this is a message, as probably a lot of you know, from back to the old immigration code, where there were people who were knocking at the door and people that were actually keeping. And this is like a really confusing concept for defense attorneys, but I'm in a crowd of volunteers, so this is probably going to go a lot smoother than it does when I do this with defense attorneys. So obviously, depending on your client's situation, you're going to be more concerned about one of the grounds or the other, right? Your client's seeking relief, you're probably going to be looking at inadmissibility. Your client already has relief, you're going to be looking at deportability. A lot of times, though, in the criminal context, sometimes we can't, they're going to be inadmissible for other reasons, right? That have nothing to do with the criminal charge. Or they may not be able to stop deportability, right? They're committed an offense to make it deportable, but we may be able to preserve relief. So I sort of think it as a two-step issue. And they be placed in removable proceedings based on this conduct, and will we have relief once they're in removable proceedings? And obviously, you have slightly different considerations depending on the client's status. Also, when you're paying your non-citizen clients, remind them that when with green card holders travel abroad, they're subject to the grounds of inadmissibility. This is like a terrible surprise that comes up all the time. That is so many clients with less than 30 grams of, not my clients, later. I didn't advise my first month, when they have like less than 30 grams of marijuana, they weren't deportable, they go on a fantastic cruise vacation, and they come back to the border, and that, small possession of marijuana comes up, and then they're deported for re-entry into green card holders. So it is worth reminding green card holders about that, because I think we spend a lot of time advising we're keeping them at deportation, we forget to remind them about the travel. So those, yes. So now, types of inadmissibility and deportability. There's a bazillion types of inadmissibility and deportability. Some of them are really fun glimpses into the past, like they're real concerned about membership in totalitarian parties. There's some foreign policy grounds, there's some polygamy grounds, always fun. But we're not going to talk about those today. We're going to focus on really three grounds: grounds of deportability and inadmissibility, the health-based grounds, and the conduct-based grounds. One last definitional thing, so it's really more for later on about conviction. So like I said, we understand that the first conviction, the immigration statute says any plea, any admission of guilt adjudicated by a judge and a restraint on liberty or punishment is a conviction. That's a really broad conviction definition, which is why I defer and unfortunately all of the definitions is just so broad. But that's why those pre-trial diversion programs are so great. You never admit guilt to the judge, you never plead in any way to the judge, right? It's all in agreement with the prosecution and the defense and then that outcome. So as a reminder, though, always having a conviction definition is possible because sometimes you get creative outcomes. I had a guy who was up the other day on the green card holder for like up on a weapons charge. Like having an argument with his neighbor was shooting into the ground. The weapons charge is really bad for a non-citizen. And so I was thinking, it's disorderly conduct and that they were not having me at all. And so what we were able to draft was a reduction agreement with me and the prosecution. Poor guys who like a million class. Like classes didn't even relate to the issue. I was like in a growth class. But whatever, I didn't care. Like I said, that agreement with the prosecution, I mean, that was that. Like whatever it takes, we needed that charge to submit, and we were able to work that out. So I think there's a lot that you can do with those agreements, try to get stuff that's more beneficial. So all the prosecution and the other day is like, are you the prosecutor? Who wants to come out and the gym's like, what's the problem? Because they weren't going to give me any sort of reduction I needed. It's fine. You offer to take my time and probably does. But I think there's a lot that can be done with those network agreements. That's what's pulling down. So basically, those kind of pre-trial agreements. Sentence, obviously, as you guys know, is any period of confinement, even if suspended. So in Texas, there's deferred adjudication and there's straight probation. This is really confusing when I first started. Straight probation usually looks something like 180 days suspended over 1 year, or 5 years suspended over 10 years. So because immigration goes to an offense attorney, that's a probation, right? Got probation. If you violate it, you get 5 years in jail. And probation, the class of probation. For an immigration attorney, you really wanted your ear up to that one because that's a 5-year prison and obviously that's really bad for immigration. Okay, but the great news, and what we'll talk more about now, is that anything processed in a juvenile court is not a conviction for immigration purposes. That means you try to send this again, it's not coming back. Yeah, so that there are those prison terms that they put you in for operation is yeah, I know, and they use it a lot. They use it a lot. What's your where are you in the state? In Harris County, do they use shop a lot here? They don't use it as much in Dallas, but yeah. Yeah, it's a really basically they shop the person, throw them in prison for a short period of time, and then set them on probation to let them stay with them. I mean, that's why they call it shop probation, and it's bad, but that period of time, that period is confined to shop probation. So juvenile adjudications and immigration. The big case on this one is matter of Devison, and this is just an awesome case. It basically says anything processed in juvenile court, and anything that happens in the juvenile court, like I said, determinate, indeterminate sentences, even though like more serious juvenile offenses, if it's processed in the juvenile court, it is not a conviction for immigration purposes. And there's a couple cases that go along with matter of Devison. There's this case, matter of an MU, and that's a BIA case from 1944, unless I wrote it down wrong, maybe 20 cents. Admission to a crime that occurred when you were a kid is not a conviction. I mean, you can't punish as a juvenile for the admission hearing, like under the admitting a crime from one person. You admit a crime that you committed when you were a juvenile and shouldn't have that effect. If you couldn't have been deported for it, right? Also, there's a matter of ON, holding that a crime committed by a minor in foreign jurisdiction need not be considered a crime involving moral turpitude if the minor would have been treated as a juvenile offender in the U.S. And lastly, matter of SIJS, again, admissions of guilt for juvenile crimes committed when you're juvenile should be okay if they would have been treated as delinquency offenses. Certified youth are different, right? So sometimes in the juvenile court, if a case commits like a really serious offense, emotional abuse, really serious offenses, they could say, we're not going to handle this kid's case in juvenile court. We're going to certify them as an adult, and their entire proceeding will happen in an adult court. Certified cases are convictions. If they hear the cases of person in adult court, it doesn't matter how much. If even an 11-year-old is certified as an adult, that's an adult conviction, regardless of their age. Okay, so we're going to talk a little bit. So great. So juvenile convictions aren't juvenile adjudications are convictions. Great. This is why, like the first time I did training for juvenile offenses, it exploded their brain that they had an innocence at all. So they're not convicted. Somebody told me that. They don't even have to be them if they're not citizens. Let's say, well, yeah, that's one ground of inadmissibility or deportability has to do with convictions. But there's a bunch of other things that can be triggered just by the conduct. So, like I said, there are conviction-based grounds, but there are also health-related grounds and grounds just related to conduct. So there's also in your folder like a cheat sheet that I have, a one-pager that should be at the end of after my packet. That's this chart here. It's probably a little bit hard to read. But basically, there are ways that things that you do wrong as a juvenile can still affect this adult. So we're not worried necessarily about conviction-based grounds, but other conduct-based grounds that we're thinking about. So it's basically when you look at the INA, when you're looking at the immigration statute, you're going to see in there that the word conviction comes up a lot, but sometimes you'll just see the word conviction, right? That's true for prostitution, for drug trafficking, for human trafficking, money laundering, and alien smuggling. Those are all conduct-based grounds for in 1282, but they don't reference conviction, right? They don't reference the conduct. Then there's these health-related grounds, right? Drug abuse and addiction, and a serious mental health condition that poses a current threat to self or others. Those ones are interesting. I have some experience. Generally, you have to be currently a drug addict or currently a drug abuser to normally have a lot of help with it. You still have a medical exam, which I had cases where able to win my first went in, saw a doctor. The doctor said they're no longer currently an addict, and we were bringing it. The same thing with the mental health issues. The person is discharged and medicated at the time of the substance abuse and fine. But there's definitely flags to look at and to delve in further because they are not disabilities. There's an interesting exception to false claim. There's false claim to citizenship. Violation tragic, but the only way you can really violate a no protective order and not be deportable is if it's like a CIMT. So we fight those cases really hard. I try to do this outright, and like I said, gang membership isn't exactly a ground of inadmissibility, but as you guys know, it's a really bad discretionary factor. And now under the priority enforcement program and under DACA and DAPA, they were really interested in gang membership. So that's another one where you don't necessarily need conviction. One last little reminder about this slide is that just remember when you're seeking relief, the burden is on you to show beyond show clearly and beyond a doubt that they're eligible for relief. And when they're proving deportability, the government has a pretty high burden in clearing evidence. So just sort of keep in mind sometimes ambiguous records or convictions that are kind of on the borderline, sometimes that works in your favor and sometimes. Some think it's not a ground of inadmissibility. Yeah, I was thinking it's a bad discretionary factor. Yeah, I think hopefully I marked on the chart. Yeah, it's not exactly a ground, but DHS takes it really seriously. Normally, I don't know if you guys are seeing it flagged a lot. It's usually just in the state or local gang database, and the police are pretty chill if you call them and ask them if I find them in the gang database. I thought I'd stop calling them and look it up. That's the risk. Sometimes you can call your local police on the net. Unless you don't want to know, and then that's an ethics question. We can talk. You can deal with that one later. You're like, oh, yeah, which I've been, we've all been there with clients before. Yeah. Okay. So, yeah, all right, I'm going to move on to the next slide, which is about juvenile records. This is really interesting. And I was in Southern California before. California has really awesome confidentiality provisions related to juvenile records. It's really, really hard to find out about juvenile adjudications. Unless you have, like, a leaky bad person at probation who's sending records to ICE, which did have happened. But generally, the state, I could object to them. If they brought those records to immigration court, I could raise all hell section 15 there. That was really fun. I got to use the PA committing a misdemeanor and the judge. That went over well. But there's Texas does not have quite as airtight confidentiality related to records. And one thing that was really interesting to me when I was talking to people in Dallas was that first thing I called over to the juvenile records and I was like, hey, so what's your guys' deal on if I called you? Like, oh, send them anything they ask for. Okay, so that's an education we can do internally in my county. And I think everyone in their local county should call their records person and have conversations that maybe that they don't know. People think police. They think that they work in a criminal statute. They think that it's like working with another county with the same sort of warrants and the same sort of procedures. They don't understand that ICE has like no rules, that they're like, just doing whatever they feel like. And I think it's really important to talk to your local records department about why they probably shouldn't be sharing with a civil entity. That's a really key distinction for the records person. Because normally they don't share criminal records with other civil entities. So I think it's an important reminder. One thing that was interesting, though, she says that they don't call very much. What happens more is the kids come in to apply for DACA and DAPA. I told them that they need to get the records. And normally to get your records, even as the subject of the records, you have to get an order from a juvenile court judge to release the records, give you the physical records. So these kids are going in front of the judge saying, Immigration wants my records. Or I'm not even saying that. Saying, I want my records. The judge is releasing them. Now, I wish we had had a better system to warn the kids. Why don't you explain to the judge real clearly what you need the records for? Because maybe the judge is going to say no, and then it won't be your fault. We'll go to immigration. I forwarded. I want to give you my juvenile records. I did so much, but I couldn't because the judge said no. And I think that we had a better, and that's basically what we were doing in California. We're saying, we requested the records, Your Honor, but we explained what they were for, and the judge was being released. Not bad. And I think especially the records are thorny. Juvenile records, and if you guys have looked through them, kids talk so they talk. I was reading one the other day that says, I smoke a pound of weed a day. Pretty sure you don't smoke a pound of weed a day. Pretty sure that's you being a teen, like a 15-year-old bragging to the officer you're talking to, right? They make crazy stuff in there, stuff that's definitely not true. Like, you don't want these records out. They're ugly, and there's a lot of bad stuff in them because the kids are, they're 15. Not that I remember that well in that age, but they've got a lot of swagger, So, you really want to keep the records out. And I think that juvenile judges, I've met some juvenile judges out, they're really nice people, and they want to protect the kids. If you said, these check the exact restriction rules. But you could also go, and this is the other thing that I think is on the slide, is try to steal the records as possible. And I don't know all the details of that process, but that's the thing. The second that they can, they need, even if they show up, so even with the unrestricted access issues, my understanding is that ICE can't get the paper records without a court order. Even though the title of the charge will show up, they shouldn't have all that terrible stuff that they give the probation officer and told them like that. To get told that health-related ground, the mental health ground, and it's stuff that goes really, really bad. It goes down those by the evaluation of the debt. Yeah. So I'm gonna. Okay. So I'm gonna talk a little bit now about criminal bars, SIJS. But one thing I wanted to flag, the silver lining in your kid ending up in juvenile delinquency is you can get the predicate order in delinquency proceedings. I did it just a couple months ago. The judge signed it like that. She had no idea what it was. The government attorney, the DA, the juvenile DA, had no idea what it was. And I was like, this kid, their parents, so sad. And they were like, oh my God, and it's not like that. So do that. You should be doing it in juvenile proceedings, and especially if you guys are starting. I know that sometimes the juvenile, the family law judges, whatever, are getting a little like tired of signing them, sick of hearing about it. Well, it's not true in the delinquency side. And the delinquency judges want to help these kids. And what an amazing turnaround of events to have a kid arrested and then have it turn into the way that they get a green card. So it's really awesome. And yeah, and this is actually true in California too. We were having an easier time for a while getting to the delinquency or anywhere else. This is due to the judges. And yeah, and they want to see the kids get better. And I think what's actually interesting with the delinquency judges is I think they recognize the trauma in a special way, and that they realize that these kids are getting in this trouble for a reason, right? And so I think they can actually be very sensitive to the stuff that you're talking about. So yeah, do it. It's fun. Okay. Criminal court SIJS. So they have the weirdest adjustment statutes. I realized I haven't done an SIJS adjustment, so I was like, they have adjustment in 245A, and then I was like, what the heck is 245H? And you guys, it's really weird. So there's different, you guys have a totally different set of adjustment factors in terms of criminal stuff. So you can have a waiver for basically anything under 212A2 except for class and moral turpitude and drug possession. So like a lot of the weird comments based around waive no problem. But then you can't waive the crime of moral turpitude, which just like blows my mind. But that's how your statute looks, guys. So and then the TVPRA added that special exception. So that's great. So these are basically the criminal bars to this assessment. A lot of them are subject to waivers, and except for crimes of moral turpitude and drug convictions. So you can waive 30 grams or less for marijuana. I guess you guys maybe already know this, but yeah. So these are the bars. Bars to asylum are slightly different. The big term of argument is particularly serious crime. Those are the things that are going to mess you up for asylum. And what's interesting is the term particularly serious crime is a little no other conviction grounds, right? So we talked about the health-based grounds, we talked about some just conduct-only grounds, and now we're going to talk about the conviction-based grounds. So the grounds of inadmissibility and deportability look really similar, but they're not exactly the same. So you have like weird circumstances where like a firearms offense won't necessarily make it acceptable, forcible things like that. And like I said, but to always remember that when your green card holders are traveling abroad, they're going to trigger inadmissibility. So like with the green card holders already adjusted, while you actually know the case, and they buzz you and they're like, hey, I was arrested. And you're going to want to be advising them. So principal turpitude is a really also another place where it's been great to get a definition in the code. It's a big issue with immigration, but they don't define it in the criminal code at all, in the immigration code at all. The case law basically says that it's crimes that sort of shock the conscience or morally reprehensible, as per, and then if you, I don't know if you guys have read the old criminal law for cases, they refer to like really out of date things like one of them is the operation of a body house. That's criminal law turpitude. Don't go operating a body house, even if it's a great idea. So generally, what we get from the case law is that the crimes against the person, murder, manslaughter, aggravated assault for general criminal sex crimes, rape, failure to register, prostitution, crimes against property, with theft, things like that. What are not are basically things that don't have mens rea. So DWI is not a crime of moral turpitude. UMV is my favorite felony, non-crime of moral turpitude. We get a lot of people who do UMVs. Criminal trespass or mischief. We also got a really great case last month. Simple assault is not a crime of moral turpitude. Again, the Fifth Circuit picked up the mess that they had made in 2016. Basically following Massive, Supreme Court came down and was like, everybody, but we need to actually bring the categorical approach correctly, being careful how we analyze these. Simple assault is safe again, which is really great. The next one I want to talk about is if your claim has a crime of moral turpitude, what's neat about the young kids is they have a special exception that I never use anywhere I've worked outside of Texas, which is full offender exception. So normally a crime of moral turpitude is making it inadmissible, but if the crime was committed when they were under 18 years old, then this is what 5 years of life status. But if they committed when they were under 18 years old, there's a waiver. And it's kind of like regardless of their sentence on it, it's a really great waiver. And like I said, I've never used it anywhere because most places they use for adults. You're not an adult grade, so it's a exception. I thought when I worked in California, when I came here in the FD, I did not know the problem is this delay between the conduct and the cooperative and the drag. But it's a great one if they're not gonna, if they don't use it for the way. Great waiver to have sort of in that pocket. Yeah. Sorry. So one thing that I also want to talk about, and this is an adult, another adult conviction, is that aggravated felony. I think most people are going to know what an aggravated felony is. Big, bad, some of the worst immigration outcomes we have, and more responsibility. But we've gotten a lot of really good case law recently on how we analyze whether the state. Everyone should know what the categorical approach is. No. Great. Okay. So I just know that. So when you're looking at whether a state is going to trigger an immigration outcome, it's a little tough to see, right? Like on here. Because if you have a theft offense with a sentence of a year or more, you are an aggravated felon. Well, how do I know that Texas is a burglary? How do I know that Texas burglary is what they mean when they say a burglary offense with a sentence of a year or more, right? These statutes are really very across the country. So how do we figure out if the state triggers the federal immigration outcome? What we do with that is something called the categorical approach. Basically, take the state statute, take the federal definition or the federal statute. Because sometimes the federal statute will say, as defined in, and they give you a really neat definition. Or there's like a really clear federal base that gives you the elements of burglary. Like in Taylor, it's the Supreme Court versus Taylor. The burglary is an unprivileged or an unauthorized entry into a building California burglary isn't burglary for immigration purposes, which obviously all the lawyers and us love that, right? That's why we did this, and we just learn what it is for people. And that's what categorical search is all about. I did a case in California where someone was soliciting sex from right on the internet. Never heard this story with a non-defense attorney test. I'm going to tell them, yeah. So he was supposedly soliciting sex on the internet. But the California, so it looks like sexual abuse of a minor, which is absolutely aggravated felony. We have Supreme Court holder. But the California statute is written crazy. California statute says one who solicits sex from a minor for one who appears to be a minor. So it could have been like dominant base sending the other side of the messages. And so we were able to say that he wasn't an aggravated felon because in theory he solicited in California for soliciting sex from a private state. And that was not enough to put it down. So the categorical approach is really powerful. Sometimes statute stuff looks really bad. So a lot of times the defense attorneys say, oh, this is his charge. This guy's got no chance. A lot of times it's really complicated. And there's interesting gaps. So, like I said, as the Supreme Court has had a whole line of really great cases on this stuff. There's lots of cases, massive, where they're really strengthening it. The whole thing with immigration law is in the conviction context is really different than the conduct context. The conviction context, you don't care what your client is. You care what he was convicted of, and how that charge matches up to the federal charge. I get a lot of calls from my clients because my client said, nobody cares. What we care about is what was he convicted of, what were the elements of that statute, and how does it match up to what the federal requirements are, right? And that's why, like, for this guy with the gun charge, at the end, we cite him for non-felony. That ground of deportability requires a conviction. So he's not deportable because the only thing they're allowed to look at is what he's pled to, disorderly conduct, right? So I think it's hard to sort of disengage what actually happened from what the court terms. Yeah. That's awesome. No, your husband is awesome. That is very uncommon. Yeah. No, it's really uncommon. And that's a lot, a lot of the jobs that defense attorney and often defense attorney of immigration explain why this matters. Right. Well, so it's, in some ways, right. Right. So Congress has says the Supreme Court gives just and the defense attorney passes by all non-citizen clients to the immigration customs system. But a lot of people don't know it because it says that the defense attorney has to have immigration useful outcome. I carry that quote around in my pocket with me every day at work, and I like to come down to the court and bring it out. I'm like, see, I'm not making this up. And I think it's tough because I get it, right? The attorneys want to see what's deserved. They want to see the person punished for their misconduct. But there is often a way to do that is immigration useful, and it's not punishing consensus. And that's what I was saying on the immigration understanding. No punishment is not used in other cases. So what can we work out with immigration is training to defense constitution and it is a lot of times there's an option. I just hit a guy up the other day, green card holder with theft $10,000 or whatever, theft $3,000 with a car. But I was able to They don't always have a lot of time to prep for cases, so they love putting up fiction-based grounds. And I have to say, in my experience, the advance with these grounds less. It's harder to prove a thing that occurred without a document than it is to prove a conviction, right? So I think in some ways, although these seem scary, it's a good job keeping the records so you're safe, right? There's government often doesn't find out about stuff. And even if they can find out the name of the conviction, it doesn't necessarily mean that it's probably the problem. Careful about how you use the court. Yeah. Okay. I'm going to go back to we talked about aggravated felony. There's a really cool section of the text. Yeah, if you're you, I think you guys will talk about the ethics of that. I think not fun. Hold your hand. And that's all I'm going to say. Not fun. The adult content, yeah, I mean, if you admit marijuana, 485 adjustment is very relatable, right? Because we prefer marijuana. I think at least there's super eligible. Go ahead, but that's probably more than that. Admit that drug use, you're going to have to. So I'm going to talk a little bit about detainers. Anyone detainers on juvenile delinquency? I hope not. Okay. This is a really big concern. We had an issue in California where we had like a really zealous probation officer in records to ICE for kids, and obviously that was a monster. Okay, those people are officers can answer. They're lovely people, but that's a mistake that they're making that can be corrected. So first thing, there's got to be, that's garbage. Okay, so there's some education that we can do to fund to understand the rules. I think this is what I'm thinking again about the civil versus criminal entity. I think that those, I think the records, this is where we can be better advocates about educating about who ICE really is. I don't think so much who ICE really is. Well, actually, but I also mean just that they're civil entities and that they don't really have the right to speak and the right to act, right? A lot of times there are exceptions from the law enforcement share information, but it's really for the prosecution of criminal offenses. It is not for dealing with civil offenses. So I think with a little bit of education, we can try to go out those holes. Yeah. So one thing that I think that we also want to talk about with this, actually this is the perfect time to bring this up. It's about the priorities of So does everybody here know generally how S-Comm works? Does TAP work the thing? So I don't know how years left communities, the way it works is this awesome. Our kids in here. Person was arrested, her fingerprints were scanned, and what the communities did, how they linked all of the local database in the jails, the FBI, immigration. how it happens. It's weird. Okay. You believe that, right? But that's what happens. They fingerprint stamp, they call over and they keep them hold on to the person. That's how S-Comm works. S-Comm was massively unpopular. And not only unpopular, it's illegal. So all sorts of people start trying. This is really interesting Fourth Amendment issue, right? Local jurisdictions are holding people who have already finished their criminal cases when they start with no new criminal cases. They're holding them for what? And ICE is, as you know, it's not like they're holding them. It's definitely not a warrant, the ICE rule. Not based on probable cause. So have you guys seen new detainer forms? I love this. It's like so drafted by non-lawyers. It's just for the probable cause. Yeah, oh yeah, yeah, probable cause right here. Check that. Check probable cause. I don't know what you're so talking about. Check probable cause. God. And I'm like, what is that? What was it? So there was a lot of problems with the way that they were law. All these people start getting right to the whole bunch of things. They were like, this is a mess. Let's get rid of this. And I was like, but then that comes out, and it's exactly the same. It's her community. That is a little better in theory, right? That sets out a guideline, right? We're not going to put a hold on everybody. We're only going to put a hold on the worst. Who are the worst? Someone with a DWI, basically everyone I know, is the worst of the worst. Really unfortunate. Their part is the worst of the worst. So that came out. But I'll tell you, we started off in holding out. Before anybody with an accident had a hold. Then test comes back. You're supposed to have a conviction for one of these. Conviction, right? Not conduct, conviction. And we were super, super, super happy. We were like, well, okay, not this is over stuff. We were like, that's a lot. But then there was a new one. One day I started seeing all these circles. It was like a pending petty theft, literally in the supermarket. And it's a fool. When I call over to ICE, I have like one of those conversations with them, and then I tell them they were not speaking their language. Like, this federal language is not federal language. We're in France. So, okay, I know I need to by that. Let's go over to jail. And I talk to them, oh, what are you guys doing? You guys are where do you live? Get on it. And I see the I-47D, which is the form with our husband. He's like, oh, no. Not all the people said, no, the two were dead. And I was like, oh, what is the point for that? So he sends me over a blank one, and it's a hard one. There's a federal interest in detaining this person. What? I know! And so I saw when I saw it, and it's a terrible form. You love it out. Good news about this 47X is it's discretionary. I think that we can push justice hard back on every single 47X. That is my goal. I want to make use of the 47X. It's a nightmare for ICE. Every time they use it, we should be pushing back. We should be arguing discretion the other way. So like you're talking about, yeah. So my guess is that they're probably using 47X. I don't know what form they're using in the whole now. But you should be calling the ICE officer. I mean, if your client has a subpoena, get a copy of the subpoena signed by somebody. Call that person and start pushing back. Why are you what's the federal interest in detaining him? You can push back on it. I'll tell you honest. I mean, a lot of times I have no luck. You know who's charged with the priority offense? They're putting 47X's on and they'll list them and we get dismissed or reduced sometimes. They're very strictly about reduction. I'm not totally sure. I mean, I think the first thing that needs to happen is what's happening in probation is probably the first thing that needs to be addressed. And like I said, if nothing else, I've been meaning to write a little short legal memo on how I see this, and I should do that. And I know it's something that's only me. That would be great. Maybe we can get something in writing and send it out, and then people can have at least something on paper to advocate for their local probation. Last time, that was it. I sent the slides. Especially the Defending Immigrants Partnership, they have really great stuff on their website. It's free to sign up with them. And you probably know what is ILRC is really great. But and then National Immigration Project. So I mean, if you ever have a really complex immigration project, you can check this gigantic planner who's the nicest in the world, and we'll talk to you about that. You know, so everything's on there. And everything. Thank you so